Well, good afternoon, everyone, and thank you for attending this month's webinar. We have a very intriguing topic, and we've dabbled around other compliance issues during the year. But what does it take to stay compliant in 2025 and beyond? That's an intricate question. Many people had theories that the CFPB would not be in place for some time after the Trump administration. We all know that's not only are they that not only is that not true, it's something that's escalating and heating up. Now, during the last 2 years, we've seen quite a few actions and more interaction with other interagency type of politics and task force between the Federal Trade Commission, the CFPB, and others. So let's take a look at the Department of Justice. Let's go ahead and take a look at some of these. Before we start, I want everybody to go ahead and read the legal disclaimer. This is for educational purposes only. Like we always mention on every webinar, this is not or does not constitute legal advice. We're not practicing law without a license. You should run any information that you warrant or all of this information by your legal counsel, especially if you're going to implement legal processes that may affect your business. While we strive to do the best and to be as accurate as we can with our own internal counsel, with our own research, and multiple people working on different topics, we may get something wrong, and we express no warranty around this. And compliance to us is very important, right? We've always predicated on this. So we want to remind you that compliance varies from state to state, and it's from where your customers are. So if you're working in multiple states, where the customer is from is where the law applies. So please ensure that you comply with all of the local regulations, and obviously with Credit Repair Organizations Act, that you're following the Fair Credit Reporting Act, and that you're trying to not bind yourself to the telecommunication sales rule. Or if you are bound by the TSR, you're going to see again on this call why what are the things that you should not be doing if you are. So having understood that, how do we avoid being intervened by one of the regulatory agencies that are monitoring credit repair actions? Well, just so that you understand what the scope of this is, in 2024 and since 2018 or 19, the CFPB engaged Lexington Law and creditrepair.com. In 2024, they established what the penalties were, and that resulted in one of the largest penalties in our industry and history. It's a $1.8 billion redress. That means that they've got to make it right by either paying back or providing services that add up to $1.8 million for advance fees and deceptive trade practices. Just so that you know, in 2004, 2005, 2006, there were also interactions from the Federal Trade Commission that really focused on advance fees and deceptive trade practices, as well as deceptive marketing practices as well. So this is not slowing down, ladies and gentlemen. This is escalating, and it's becoming more aggressive. Compliance is not something that you want to think about adding to your business model. It's something that should be part of your business vernacular. That means it should be an internal process. Everything you do should be, you should ask yourself the question, is it compliant or not? And many of you have spoken to me before in the past, and I'm always that guy on the conversation that says, let's look at it from a compliance perspective in some way or some form. And I don't do that because out of just being obtuse. I do that because I had a credit repair business, and we were intervened not once, not twice, but 3 times by our local regulating body. And it was some of the most some of the worst times of my life were spent trying to explain why we were doing things the way we were doing them, and in some cases why we did them wrong because I didn't know any better. That's why I built ScoreCEO, or designed it to be built in a compliant way and help credit repair organizations stay compliant and be successful. It's a great tool. If you don't have it, take a look at it. And we're gonna show you ways that some of these things that you're doing in some of your CRMs, yeah, it's important to have sales, but I say it's important to have sales every day and in the future, without and going to bed and sleeping well at night, not concerning yourself with compliance issues, because if you're failing to do something in a compliant way, it's not because you're not trying and you're not trying to self-regulate. And ScoreCEO offers you the platform to do that. You've got to be an expert with CROA, the Fair Credit Reporting Act, and the TSR. But not only an expert, you really have to understand how each one of these different pieces of legislation and I would say rulings work together. They really work together to protect you from yourself, you as a company. Okay, they also work together particularly to protect the consumer. But at the same time, if our interests are aligned with our consumers, because we have a great a compliance strategy and process within our ethos of our business, we're also protecting ourselves if we're protecting the customer. You have to underpromise and overdeliver all the time. You've heard me say that on many calls, on some of our conversations together. I suggest that you read more into CROA and ask bigger questions. Just to mention, there's a great place to understand CROA, FCRA, and the TSR is by having conversations with the people from NACSO. So remember, NACSO is probably the largest and oldest and most connected, I would say, group that represents the credit repair business owners in our space, or credit repair organizations. It is the de facto service organization. They do have lobbyists, they engage lobbyists, and they have prevented legal action in our space in the past. We need to keep that voice alive. So remember, take a look at NACSO if you haven't done that already. Discover how to turn your compliance, and I said this before, into a competitive advantage. What is equal is not an advantage. Every credit repair organization needs to comply. And if you don't want to be bound to the TSR, well, then don't be a telemarketing company in the eyes of the TSR and now the Federal Trade Commission. Okay, you have to act as if your customers are coming to you and making their decisions on their own. And we have some webinars that we've covered topics on this. Jasmine, you may want to add those to the chat for everybody to refresh their memories, in maybe after this call, by taking a look at those webinars and those documents that we published around how to use ScoreCEO and what to do on your websites and what not to publish, like phone numbers, and when to talk to customers before you start talking about your products and services to them, and when to talk to them about those products and services in a legal and compliant way that may not bind you to the TSR because you're not telemarketing to them. Okay, compliance is, if you preach that compliance, the first people you should preach it to are your potential customers. It should be written all over your websites. It should be written. You should let customers know that there are rules in place, and you abide by them. If they chat GPT and validate your content, they will see that that is the truth. And making unfair and deceptive claims could be something that they want to stay away from. What you should be taking away from this webinar: number one, reinforcement. We want to see reinforce the understanding of what these enforcement actions were. We're going to go into dive a little bit deeper into that settlement in December 2024. What do we believe are the coming priorities for the Consumer Financial Protection Bureau? Are they gonna disappear, or are they gonna escalate? That my understanding of that has changed over the past year and a half, and I believe that they are going to escalate. They are working together with other agencies, and they're looking to proactively and on purpose engage customers that are taking fees in advance of completing those services and misleading their customers by saying one thing and signing something different in their contracts. By the way, this isn't anything different than in other industries. Like in the automotive industry, there was a practice around signing blank contracts, for example. And then contracts would not meet customers' expectations because it would either be higher or even lower in some cases, but most of the time different than what they agreed to verbally because they signed a blank agreement and then they filled in the numbers later. Many companies were engaged by the by the Federal Trade Commission and other institutions as well, particularly in California and bigger states that had a lot of this unfair and deceptive trade practices going on. And if you don't want to be bound to the rulings of the CFPB about taking fees 6 months after the fact, well, then you should not telemarket. And to not telemarket, you should not be promoting your phone number, promoting talking to customers on the phone or on video calls. You should very easily have a process where customers digitally can navigate to a point where they can go ahead and then talk to you without binding you to the TSR because you're not a telemarketer. These are things that you need to do on your websites. I know you want all of that business, but are you willing to put up with the regulatory constraints that bind you to that business? That's the question. CROA, the Fair Credit Reporting Act, and TSR, you should clearly understand what it is after this conversation and this webinar today. But you want to go ahead and dive in. I exhort you to go ahead and dive in even deeper. Spend some time reading that 90-page Fair Credit Reporting Act document. And it talks about, yeah, we can dispute things, but saying things like it doesn't belong to me, it's paid as agreed, it's not mine, it's in duplicate, that's something you need to stop because you don't know if that's true. And you should only dispute things that you know are true. And correctness and being 100% verifiable is the way that you dispute, right? So you have to dispute factually. There's no other way. And you want to go ahead and use compliance as a competitive advantage. Promote that. Tell customers, inform them, educate them, let them know. As a matter of fact, that's exactly what the CFPB and the Federal Trade Commission want to see. They want to see companies that actually make those expressions and back it up with action by mystery shopping. You don't think that they're not watching. They are watching. All right. From a procedural perspective, what do you got to do in your business to go ahead and change your compliance framework? Do you have a compliance framework? Is compliance something that you say or something that you do or both? If so, how are you doing it on purpose, and how is that self-healing itself? How is that self-educating every member that comes on board into your company to go ahead and treat your customers the right way and express themselves the correct way? These are things that you need to not only educate on, you need to continually educate on, and you need to test. And you have to take action. If you find a mistake, think of it as a good thing, because you want to document that mistake and you want to go ahead and put it on a list somewhere and make sure that you educate everybody as to not what to do, which you found. All right. Now, if it happens on multiple occasions, then it doesn't get better. Then you need to analyze your compliance framework and the personnel managing that. Right. But we'll talk about how to do these things and go ahead and make sure that you interweave it into everything: your sales, your customer service, your automation, your billing. Everything has touches compliance in one way. We're going to look at some of these cases that actually were companies that were engaged and fines were attached to those issues. We're going to see how they it affected them, and for those same reasons, these are the reasons why you should embrace compliance as a framework within your business, just like you embrace your sales process and your sales funnels in your businesses. I would say even deeper, because this adds longevity to your business. And at the end of this, we're also going to provide you with an action plan. It's a 3-page action plan that really helps you set up a compliance infrastructure within 90 days. And you're going to go ahead and build that out over the future of your business, because it should be an organic process. When you can, and Jasmine has come up with a nice document that helps you focus on your priorities for 90 days to get that roadmap implemented and let it grow from within. Let's look at what's happened between 2018 and 2025. Well, we all saw the CFPB and the FTC work together. They started to do so, and they started engaging smaller companies and eventually much larger companies. They've even engaged companies in our realm, in ScoreCEO's realm, like software companies that make made the wrong choices, and they said the wrong things. They were making claims that were unfair and deceptive from the moment that they were selling software and protocols and processes and websites. All that would trickle down, and it was okay. And they were teaching their customers how to say things like, how you can guarantee an inquiry removal in 15 days or something like that. You can't do that. You can't guarantee results. You can't guarantee anything. You know what you can guarantee? Sending a correctly structured letter in a factual way. That's all you can guarantee. Anybody who says different either doesn't know they're lying, or they're blatantly lying. Either way, that is an unfair and deceptive trade practice. We need to stay away from that, ladies and gentlemen. Has anybody done it in the past? Well, audit yourself. When you download that 90-day action plan, do it with the intent and the intention of self-regulating your business. In December 2024, they put a number and stamped a huge number on it. This was done on purpose. This was done to send a message saying, we will not tolerate this. And that still hasn't put Lexington Law and CreditRepair.com out of business, but they've changed everything on their website. Try and find a phone number on their website. Everything is channeled towards getting them pre-qualified and getting a bunch of things in place, like submitting their credit card, like signing an agreement, like choosing the service on their own, based on their own, on an automated analysis of their credit report within their sales funnel. They're doing all of these things, and they only talk to you only after you've made the decision to purchase and you've done everything else. Okay, they'll chat with you, but they won't talk to you in person, and they won't do video calls anymore until you're an actual customer. So we want to take care of that, because that cost them a 10-year ban from telemarketing at all. Now they can't even pick up the phone if they want to stay in the business, or make a call on the phone for that. In 2025 and beyond, will the CFPB be less or more engaged along with the other regulatory agency? Absolutely. Okay, with a specific focus on advance fees, record keeping, and the truth in advertising. So don't say things like, we can go ahead and increase your score in less than 6 months, or do it in a nice way, because the customers, they want to hear these things. They ask you, well, how long does it take? And well, normally it could take around 6 months. You can't do that. You can't do that. You can talk about historically. You can say where your results lie and how, and you have to be able to produce the evidence of how you concluded to those numbers. But the best way is to stay away from promising results at all. Under promise and over deliver, and let your customers know that, guess what? If any company is promising you results, they're probably going to also take your money and run. after they've provided you the service. So under promise and over deliver. The only thing that will stop a consumer from getting better credit is actually working on their credit to ensure that the correctness exists on their credit report. And if there's something that is listing the wrong way, you can ask for it to be corrected or removed. If the credit reporting agencies do not do their job, or the data furnishers do not do their job in benefit of the customer or not in benefit of the customer, they have other rules for that. That's not your business. What is your business is that you dispute on behalf of a customer to ensure correctness and ensure that it is verifiable. Because those are the things that need to happen according to the Fair Credit Reporting Act. It has to be correct and verifiable. That's what consumers can do for themselves, and we can do that for them. That's the service. Are there any questions till this point, Jasmine? I'm not looking at the.
No, not right now.
Awesome. So let's look at the largest settlement in credit repair history by the consequences, right? What we mentioned before for illegal fees, deceptive advertising, and violation of the TSR. Now, this was a ruling that they made. It's not the law. It's a ruling. That means they will apply this ruling the same way on every credit repair organization and or credit repair provider of services. Okay, what are the consequences for the largest credit repair business in the world? A $1.8 billion basically redress. That means that they've got to make things right and pay penalties. And that came up to $1.8 million. That's a lot of customers. A 10-year ban that for both of their companies. And they had a marketing company involved in there as well. So that disappeared. That 10-year ban is in place as of 2024. Okay. Permanent injunctions against deceptive marketing practices. That means you can't say things like, because we're a legal company, we get things, because we're an attorney-driven business, that gives us an advantage. Or even make the supposition of that. I get that question asked all the time. What if we use if we use an attorney to send it? It makes no difference. The dispute process is the dispute process. There's nothing in the Fair Credit Reporting Act that says they will honor legal grievances better than the customer service. It doesn't say that. It doesn't exist. Yet people come up with these lies to sell services, to promote, to make it look like they've got the smoking gun, or they've got this magic bullet, or this great seed that's going to spawn a credit repair beanstalk of somehow into the sky. There's nothing magical. It's all about editing customers' credit and doing it in a legal and ethical way, factually. And being consistent and letting the customer know that the only thing that can stop them from getting any results is them not doing either their own credit repair themselves or paying you to do it for them. Like washing a car. They can keep their car dirty, or you can wash it for them. That's up to them. But you can't say and make the claim that you're going to be the best car wash or the best detailer in the world. You're going to have to prove that, and that's what the CFPB is doing to every credit repair detailer, and I'm throwing up air quotes, right? And that's why I'm saying never overpromise so that you can underdeliver. Do the opposite. Never overpromise and underdeliver. You want to underpromise and overdeliver every single time, and you want to preach that to your salespeople, to anybody that speaks to your customers or communicates with them via text, email, or any other way, social media, or any other chat service. We have to be very clear on that. If you go to creditrepair.com's website and you look at some of the common questions that our customers ask, like how long does it take? How much will it cost me over time? Can I get rid of my public record? Things like that. The reality is that you can't guarantee results. All you can guarantee is execution of a process. That's all you can guarantee. The results are going to be codependent on the different situations that they have on their credit, whether it's true or not, whether it's correct or not, and whether the credit reporting agencies or the data furnishers themselves perform their due diligence in investigating adequately or not. And that's all you can promise, is to declare the process. But all you can actually promise is sending a great letter every 30 to 35 days, and or however you run your business, and monetize accordingly. If you're doing a monthly, if you're doing a pay per performance or pay per delete model, you want to go ahead and promise. If you're promising to get something removed, you better not charge for it until you do, because if not, you can be charging fees in advance of services. And be very careful with some of those first work fees and things of that nature. Okay, unless there's some service tied to that first work fee, that could be a problem. Okay, so you wanna be clear. You wanna, if you think that you can't sit in front of a judge and explain in a simple way what that means and how you charge, and if you have to explain it a lot, you're probably charging fees in advance of services. If not, you pitch it to somebody, friends, family, neighbors, your attorney, okay, and let them give you their opinions. Okay, you have to charge fees after the service is performed. If you removed an inquiry and your fee was $50 for that inquiry, and it's in your contract, and you charge $50 for that inquiry, then you charge for it. If there's a one-time fee, okay, that affects every other fee, be very careful with that, because when do you charge the totality of that fee if your results took 20 months instead of 1 month? So that $95 fee, can it be divided up into small fees? You're going to have to explain that. If it needs to be explained, you're probably going to be asked the question, and you don't want these questions asked of you. So, these paper performance plans have been put to the test, and they passed the litmus test legally in some states. Okay. But as we know, the CFPB is now looking at things a bit differently with a free hand, and they're collaborating with the Federal Trade Commission. Keep if you give a consultation, give the consultation and charge for it. In some cases, there's legal argument around charging for that fee after the right of rescission. So there's an argument that says if it's a federal ruling that says if it's bound under federal law where the customer has the right to cancel within 3 days, well, you shouldn't charge until after the third day. If your state gives them a longer time period of 5, you can charge them after 5. Well, within ScoreCEO, you can schedule that payment out. You can close today and schedule out that payment within 5 days. You can do that. You can go ahead and within those 5 days, when that action takes place, the customer can change into from a lead to a customer in good standing automatically. You can do that, and that helps you automate your business in a compliant way. Okay, so we have to pay attention to these things. Okay, it's not about not getting paid. I'm all for revenue. But I'm even more for keeping that revenue forever. Okay, and then you want to think about also chargebacks. Anybody on this call, if you raise your hand, go ahead and raise your hand if you've been engaged with some sort of chargeback that you've had to contest, maybe won, maybe lost. Okay, well, we've lost chargebacks. We've won a lot of chargebacks as well. But every single time we've lost a chargeback is because we were missing some paperwork. And every time we do, we add that paperwork, and we make sure that we have a process to minimize that risk every single time. From our point of view as a business, that's the way we look at compliance. So we're going to do right by our customers, so that if our customers do wrong with us, well, then we correct them nicely, and we let them know why they're wrong, even if they do perform a chargeback. Well, that's a way that you lose money. Okay, these are or revenue. And that increases your cost of acquisition, and so on and so forth. So your MRR goes down. I mean, there's a lot of things that you need to take a look at here. Compliance should be a corner piece in your business, and look how it affected these two companies, Lexington Law and CreditRepair.com. All right. Remember, advance fees prohibited. Marketing claims must be truthful, documented, and provable. And compliance failures don't just cause fines; they destroy long-term profitability, which is the another way of saying what I just expressed.